Welcome to JGL Law for You. This podcast is sponsored by Greenwald and Laake, a suburban Maryland law firm that has been representing clients throughout the D.C. metropolitan area and across the country for close to 50 years. JGL Law for You is a podcast by lawyers, but not for lawyers only. On JGL Law for You, we will bring you up close and personal with our lawyers and some special guests who will be discussing how to navigate the many legal processes, developments in the law, other current events, and how they may affect you, your family, or your business. Today we are talking about a very timely issue, particularly in the news with what we're seeing coming out of Minnesota, jury selection, the strategy, what goes into picking a jury, how lawyers look to pick jurors, and look for jurors who may be sympathetic to their side of the case. And talking about it today, we have two awesome guests. First is Matt Vogt. Matt is a trial lawyer here at Greenwald and Laake and in our personal injury practice. He helps individuals who have been seriously injured in avoidable accidents recover the compensation they deserve in litigation before state and federal courts throughout Maryland and the D.C. area. Matt has experience in managing a broad range of high-stakes personal injury matters on behalf of victims and surviving members, including automobile accidents, wrongful death cases, and a variety of other serious accidents caused by negligence. Also, we are thrilled to have with us nationally known jury consultant and president of MMG Jury Consulting, Dr. Melissa Gomez. Melissa holds a PhD in psychology and a Master of Science in Education from the University of Pennsylvania. She has worked on over 700 jury trials across the United States with a focus on the psychology of learning, behavior, and decision-making. She has 2 decades of experience in research design and methodology, as well as in behavioral and communication skills training. The author of 2 books, Melissa has appeared as an expert jury consultant on CNN, NPR, MSNBC, NBC, and others. Melissa and Matt, welcome aboard today. I can't wait to get this talk going.
Me neither. Thanks for having me.
Thank you, Dave.
All right, let's start at the very low bottom here, right? When we talk about jury consulting, what does that mean exactly?
Jury consulting can mean a variety of things, but what I do is I come in from the perspective of the jury. I take a look at what is happening in a jury trial and all the different aspects of psychology. So most people think of jury consultants as only focusing on the jury or only participating in jury selection. But essentially what I do is I work with all of the different aspects of psychology. What is the psychology of the witness? What is the psychology of the judge? What is the psychology of the attorneys, as well as the jurors, to see how our story comes across from both a content perspective, what is the evidence saying, as well as what are the image messages, what are the adjectives that people would use to describe us and our client, and how does that all roll together to have people understand our story.
I don't want to get too far ahead of ourselves. Are you there during the course of the trial observing not only the witness's testimony, but the jurors and how they're responding to that as well?
I can be, but not always.
Okay.
The bulk of my work happens before trial, and actually sometimes even before discovery. I have clients who contact me before they even file a claim in order to say, well, what's going to be the best venue? Or what are the different arguments that we want to put forth? Or is this a witness? Is this a case that would be palatable to a jury at the end of the line? And so I help make those decisions, keeping in mind, what would a jury think about this if this was going to be presented to them, in order to help us make those decisions along the way. And then sometimes I will participate in the trial as well. But usually by that point, I just set my clients with what they need to know and let them roll.
In terms of tools, right? What is it that you make use of or that you're looking for in order to make these predictions that you talked about in terms of jury behavior or jury responses to your client's position or potential testimony?
So there are multiple tools that we use in order to try to understand how different people might react to our case in a different way. The first would be a mock trial or focus groups where just like Coke versus Pepsi, you bring people in a room. What do you think of the labeling? What do you think of the taste? It's going to be the same sort of thing, except In mock trials, we're bringing people into the room, people from the venue of the trial, presenting the case to them. And then they tell us, what do you think of this case? What resonates? What doesn't? What's important to you? What's not? And then we can use that to help guide us to later on present a more effective argument, a more effective case in front of a jury. And otherwise, it's just understanding how the world has changed. So we're living in a world of COVID, and being cognizant and aware of how issues in our community, either locally or nationally or anything else, could affect the way that people perceive a story within the courtroom.
So let me fall back on something you started saying there, and you talked about venue. So a lawyer who's got let's say it's a wrongful death case, or it's a civil rights action, and let's use something in the news. My client was assaulted, was shot, was harmed by a police officer during a stop and frisk, or a stop along the way, a traffic stop, whatever it may be. We want to file a lawsuit based upon whatever the facts are. And I call you and say, I'm not sure where this lawsuit ought to be filed. What do you look at there, and how do you help that person?
So there would be a couple of different ways that I could do that. Number one, I would understanding what is this story and what are the issues in this story, and what are the profile of people who may or may not be on our side, or who may or may not be adverse to us. And then also taking a look at the profile of the venue is what are the characteristics of that venue. So there are certain venues that might be known to be very pro-police, very Blue Lives Matter. And there might be other areas that are more Black Lives Matter, more defund the police type places. And a lot of it goes on political lines. Mm-hmm. And so it's understanding that. And sometimes that's going to be pretty obvious to you, but sometimes the differences are subtle. And so, for example, I'm working now on a case that we have not filed yet, and we're trying to figure out, do we want to be in the city or do we want to be out in the county? And so what we're doing is we're doing those focus group exercises where we're presenting the case to people from one county and then presenting the case to people from the other county, and seeing if there's a difference. And if there's a difference that we can rely upon in order to help make that decision from a more empirical perspective.
A stupid question. How do you get people to participate in this?
So what we do is, the most important thing is that the people who participate are demographically representative of your actual jury pool. And so we collect that information. And then once we collect that information, then we hire professional recruiters, either national recruiters or local recruiters. Sometimes market research firms have those lists of folks who come in and participate in those focus group, in those other kinds of focus group and market research. We hire them. They find the people matched to our criteria. And once we approve, yes, this looks like the group of people that we want, then that's how they get recruited.
So, Matt, let me turn to you for just a second. Obviously, the practice of law in pretty much every area, except, I can't think of an area that hasn't been changed as a result of the pandemic, although there might be one out there. Certainly, your practice in terms of personal injury-related matters has changed during COVID, leading up to COVID, and now that we hope to be putting most of it, or some of it anyway, behind us. Tell us a little bit how that's changed, how you now have to plan for putting a case on, and how you might look to use a jury consultant.
Well, it's a good question, because as it stands right now here in Maryland, it's sort of the great unknown as to how it's going to affect jurors and what our jury trials are going to look like, because our courts don't open back up for jury trials for at least another 2 weeks. I was on a call with the court this morning, and it looks like it's probably going to be in some jurisdictions into the first month of May, or first week of May. And then once we get there, it's sort of the great unknown. How has the jury changed in their mind, in their attitudes, because the entire world has changed since the pandemic started. So why wouldn't that have an effect on how a juror would view the world or view a case? And I think Melissa hit on it exactly right, that it's going to affect different people in different ways. And what we would use a jury consultant for would be to help guide us through that. And I know, Melissa, you you have done, a tremendous amount of research on that you've written up recently in a couple articles. And, my question for you would be, what have you found that, the sort of 2020 effect, not just COVID, but politically, socially, how have people changed in how they would view a case, over the course of the last, 14 months or so?
Well, what we understand is that people have changed their opinion. So in our research, we have surveyed folks, and we found that of our data set, which is a little over 200 jury eligible adults from across the country, we found over 70% said that the pandemic has changed their opinions and perceptions in some way. So the issue for that is, what are the perceptions that have been changed, and how does that change of perception interact with your case story? So, for example, opinions of corporations. We found that there have been a substantial percentage of people who now feel more negative toward corporations, but maybe more positive toward medical professionals. And so really, it's just the interaction of those issues, of what's happening with them and what's in their mindset. And it's kind of similar to what happened before the pandemic. You're going to see and you're going to incorporate information in a way that which complies with the way that you already think. But because it's changed and it might be a fresh perspective, it could be a little bit stronger for them. And so the important thing is we can't necessarily predict at this point, because the research is so new and because we're just going into this brave new world of post-COVID jury trials. We can't really assume that we know exactly how it's going to happen. So the important thing is to know what questions to ask in voir dire, what questions to ask of yourself before you step into that courtroom. And potentially, if you're in the possibility of doing jury research, what questions to be asking in order to have a better sense of how people would be reacting to your story.
Is there one key question, or is there a handful of key questions that you would use or have the attorneys use to draw that out of a potential juror?
Could be just the question that I just said. How many of you feel that your perceptions have changed in the last year? Had some really, strong changes in opinions on something that you thought you knew before. You get those show of hands. You can start to inquire, get a little bit deeper into that. Another thing that we found in our research that I think is going to be a relevant question to be asked in voir dire by both plaintiffs and defendants in the next at least 6 months or so is, what is the level of impact that COVID has had on your life? Because what we found is that folks who had a stronger impact, who COVID had a more profound impact on their life, were more likely to be plaintiff oriented than folks who said, yeah, it was impacted, but it, wasn't earth shattering for me. We were still able to move on. Those folks tended to be more defense oriented.
When I used to try medical negligence cases in the first half or so of my career, and I was on the plaintiff side, I often heard from defense lawyers, either in opening or in directs of their doctor, physician clients or healthcare professional clients, was a lot of questions trying to personalize those folks. So oftentimes, in medical cases, you sue a hospital, for example, right? And so the goal of the defense lawyer was to make it. It's not a hospital. There's people that work and are invested to go to work every day in that hospital. So I'm wondering, and as I'm sitting here listening to you, I'm wondering if you may see even more of that now because of the people who, we read about frontline workers, we read about healthcare professionals being out there day in and day out, putting their lives on the line. And it almost seems to me that it could provide more difficulty for plaintiffs in certain jurisdictions to find success in those types of cases.
In certain jurisdictions and with certain case stories. So I also do a lot of medical malpractice work. And my work is almost 50-50 plaintiff and defense. And that way, when I'm working with the defense, I can say, how would I come and get you if I were the plaintiff? And when I'm working for the plaintiff, how would I come and get you if I were the defendant? And so what we're seeing is that the 2020 effect is, as Matt had said, with this healthcare heroes. It's one of the themes of the crisis, one of the things that I call the themes of the crisis. It has a very profound impact, but it depends on the issues in the case. It depends on the characters in the case. So the 2020, the healthcare heroes are really about those frontline workers. It affects nurses, ER physicians, those people who were truly in the trenches. I haven't seen that translate as much to other areas of medicine. So when I was doing research on, birth injury cases and folks that aren't really associated with the pandemic, that impact was muted quite a bit.
As opposed to EMT, emergency medical professionals, you say?
ER physician, yeah.
Okay, interesting. So when you're talking about COVID, and Matt, let me just bring you back, circle you back in here. How do you, as a plaintiff's lawyer, now that we've heard Melissa talk a little bit about juror attitudes in this regard, how as a plaintiff's lawyer does this modify your strategy in putting whether it's a medical negligence case, a personal injury case, or whatever else together?
Well, it does and it doesn't, because on one level, you have the basic building blocks that you got to put into every case. You got to start with just the basic blocking of tackling of how do you prove the elements of, duty, breach, causation, and damages that you need in order to even get your case to the jury. So you got to start there. And then the question becomes, how do you refine those basic building blocks to formulate the best possible presentation of the case? And that's where someone like Melissa would come in, not just in terms of picking the jury, but also in terms of fine-tuning the presentation of the evidence. And one thing I'd be curious in hearing from Melissa about is, how does she prepare or help prepare expert witnesses that they may be talking at a extremely educated and learned level on an issue? How do you help train an expert witness to bring that great pool of knowledge down so that a juror can understand it, process it, and have it fit within the themes of the case and the case story?
Mm-hmm. So, Matt, the first thing I want to address is the first point that you were making is how do you change the way that you're putting your case together? And absolutely right. The way that, you need to have your evidence of causation, have your evidence of negligence, causation, damages. And so it's about refining, and it's also about reframing and understanding it. So the evidence isn't going to change and the law isn't going to change, but the way people perceive the story could. So, one of the other examples of that is, another theme of the crisis, which is this profits over safety issue, where we have been dealing with for the past year with, okay, do we act in a way to protect the vulnerable and their physical safety at the expense of our country's economy? Or do we move forward with the economy at the potential expense of the safety of the vulnerable population? And so, that's a really interesting concept in terms of how are we framing our story with a common plaintiff mantra, profits over people. Does that work anymore? And so that's what we want to take a look into. And so all of the different aspects of the trial, you talk about experts, all of those different aspects come into play. So one of the very important aspects of working on a trial for me is to have that big picture perspective, is to make sure there's consistency of theme and that we're framing the case in a way that is conceptually makes sense, we're educating appropriately, and then we advocate. And that's where I come in with the experts, is having them understand, okay, here is what I say is, here is your lane. Here is what the messages that are important for you in your expertise. It's important to stay in your lane, but also making sure they understand the other aspects of the case and the big picture theme of that case so that they can incorporate that in. And so when we're dealing with highly technical information, so if you're dealing with injury cases, it might be medical cases. I also work on patent cases. If you want to talk about really, really technical and complex stuff. And it's sort of working them through where we want to let them use their language and then define it and working with them through it. So it's, I usually say, educate me. I have a PhD. I don't understand what you're talking about. So first thing you got to do is help me understand it. And then I can help you help them understand it.
Right.
So it's a process of understanding that person, understanding where they're coming from and understanding their language, because once you meet them where they are, and that's true with any witness, once you meet them where they are, that's when you can work together to get to the place where you need to be, because the experts are anxious too. The experts are, one of the most anxious witnesses I've ever worked with was an expert who was dyslexic and was afraid that someone was going to give him something to read. And he never said anything about it until I finally pried it out of him. So, it's making sure you really understand what's happening, because with some of these witnesses, you have these expectations that they're just going to be fine. And this whole process, our wild and wacky world of litigation doesn't make them nervous or doesn't stress them out. It does for everyone. And so again, meeting them where they are in order to make the change.
For sure. Here's another question I had that I'm curious about, because we talk about having a case story or a theme of the case. And when you're in trial, you've got 8 different people in that jury box and it gets whittled down to 6 when they start to deliberate. How do you thread the needle of making sure that your theme of the case, that your story of the case works for the highest number of people who are on the jury, and that you don't play completely to, 3 jurors and completely turn off the other 3 jurors? Because if that's the case, you just lost. So how do you fine tune the issues of communication so you have the most jurors pulling for you in the jury room?
Mm-hmm. Well, it's not just the most jurors, but the most powerful jurors. So sometimes all it takes is one leader. But really, that process starts in voir dire. It starts with developing a rapport. It starts with showing, with demonstrating, how do you want the jurors to see your client and see your case? What are those adjectives you want? And it's an exercise that I go through with all of my clients, all of my witnesses. Tell me, what adjectives? How do you describe yourself? How do you want jurors to describe you? Now, everyone on our side of the V has to be that. And so once you start with that sort of that image, those image messages, and you start with those themes as early as voir dire, and then you can pull people in and start to develop that rapport. And when people feel important, then they're going to be more willing to listen to you. So it's asking those questions and developing that in voir dire. And then when you start your trial, what I see a lot of attorneys do is once they start their trial, they forget about those jurors. All right, now I'm in it. Now I'm just going to, now I'm just going to go and the train is moving. What I do is, if I'm there during a trial, or even if I'm just there during jury selection, I print out profiles of each juror, and wherever the war room is, I put them on the wall and I say, you're going to look at this every single day. And when those folks are on the top of your mind, as you're telling your story, as you're developing your direct examinations, as you're developing your cross examinations, then you're naturally going to be saying things and, oh, you know what? Why don't we ask them this question? Because I think juror number 3 might relate to that. Let's ask this one that question because I think juror number 4 is going to relate to that, because you're keeping them at the front of your mind.
So, Melissa, just to jump in quickly, because some folks that are listening are not lawyers. So when you talk about voir dire, that's the process where the lawyers select a jury, right?
That's right.
And what you're suggesting, I think, is, and I don't want to put words in your mouth, but I would like you, just take a minute, explain this a little bit more for the non-lawyer folks out there, is that in selecting a jury, the question, not only the questions that are asked of the potential jurors are important, but how they're asked, I suppose.
How they're asked and how they're answered. And so voir dire means to tell the truth. And it is the process of asking questions to the jurors in order to determine whether each juror can be fair and impartial to both sides of the case. But the way that this process is used is more than just that specific task. It's just collecting information, even though collecting information is very important. But this is the only time where attorney and juror can talk to each other back and forth. It is the absolute only time during the trial. And so it's really important to take advantage of that process. And there are a lot of things that we do during that process. So we're going to ask questions, and sometimes we ask questions that are extreme. Sometimes we ask questions in order to get good information out so that everyone hears the answer. And so, if someone says, I've had a negative experience with a medical provider, and you're the plaintiff attorney, the plaintiff attorney would ask, okay, well, tell me about this and tell me about your experience. So now all of the other jurors are hearing about this other negative experience that have happened, maybe a similar circumstance. That lawyer knows that juror is probably not going to be on their jury, either because the court is going to say, I don't think that person is going to be fair, or the defense is going to say, the person who's defending the doctor or the hospital is going to say that person had a bad medical experience. I'm going to choose them as one of the people that I'm going to kick off the jury. But once that information is out there, it's also an opportunity for you to develop that relationship with them, to listen to them, to even say questions like, okay, well, what do you do in your spare time? And that sort of gives you an idea of that juror, what's important to that juror. It gives you an idea of how they talk about the things that they care about. And it also makes them feel heard. And it's developing that relationship is one of the first things that you can do to open them up to listen to what you have to say.
You're talking about developing a rapport with this individual who may be on your jury panel so that he or she is going to listen more to you during the course of the trial, I guess is what you're getting at.
Right.
He's going to feel what you're saying more because you've been able as a lawyer to establish that connection with that person during the course of this 3, 4, 5, 6 minutes of back and forth questioning of the potential juror.
Right. And it's genuine. I'm listening to you. So when people feel seen and when people feel heard, they're going to open up to you more than if you say, well, I already know that person's profile, so I don't need to talk to them. It's important to talk to everyone because who's going to end up being on your jury? And here, another thing that you're talking about with people who may be listening who aren't lawyers, jury selection is a contradiction in terms. You don't get to pick your jury. So what happens is you get a group of people. The court, because of the way they answered questions, decides that someone can't be fair or someone's not eligible for some reason. Maybe they have a prepaid vacation. Maybe they have an illness that makes it difficult for them to sit, whatever reason. And then you have a smaller group. And from that smaller group, the plaintiff gets to strike some, the defense gets to strike some. So, and by strike means remove from the panel. So you don't get to pick your jury. Your jury isn't who you selected. The jury's who's left.
It's true.
Right. And so that's why it's important, because a lot of times what I see attorneys do is they focus on their best and they focused on their worst and they ignore the middle, and the middle is going to be the group that's deciding your case.
Usually it sounds a little bit like politics, actually, to some degree. Well, anyway, historically, anyhow. So, yeah, I mean, in most jurisdictions, lawyers can get rid of some potential jurors just because they don't like them. They don't have, doesn't have to be a cause. And then in other cases, I suppose, where you see where you may flag a juror that you don't think is the right fit for your client's case, the lawyer that you're working with may look to find a way to have that juror stricken for cause, we call it, right? Try to show some inherent bias or whatever it may be. So to wrap up here a little bit, I understand you have another book that's coming out. Tell us a little bit about that.
Well, I have 2 books that are already out. One is called Jury Trials Outside In. That is a general book for both lawyers and non-lawyers who are interested in the process of jury trial. And it basically, it started as a series of blogs of war stories, of stories from the road, because I have traveled probably around the globe several times because I work nationally. And so there were little anecdotes of stories that I had seen that I thought had a bigger meaning to understanding this process of jury trials and this system of justice that we have. So that book is a series of those stories, lessons learned, and then connections to psychology, connections to sociology, marketing, homeland security, all those things. The second book is called The Witness Preparation Partner, and that is basically a manual for anyone who is a first-time witness, not an expert witness, more of a fact witness. It's an introduction to them to, as I said, the wild and wacky world of litigation. And it kind of is purposed to sort of be a reality check. So I'm sure Matt has experienced those plaintiffs who are saying, I'm injured, and when is this going to end, this process of litigation? It can take years. And it does, just because you filed a lawsuit doesn't necessarily mean that you're going to get money or get what you want or get what you think. And just because you're a defendant and you feel that you're right doesn't mean you're not going to pay out. So it's sort of introducing to the reality and then the process that you have to go through. It takes you from deposition all the way through trial. And there are two versions of it. One is just for the witness, and the other is kind of like a teacher's edition for the attorney to follow along. And then it gives the attorney little tips that, here are some things you want to talk about with your witness after they read this chapter. And it's both of them I've designed to be very easy, quick reads.
Awesome. And if folks want to read more about you, Melissa, or reach out to you, be lawyers or potential litigants, what's the best way for them to find you online?
www.mmgjury.com.
Awesome. And Matt, I'm going to assume that we've got some listeners out there who may be looking for a lawyer in the Maryland District of Columbia area. What's the best way for folks to reach out to you and find out, get information about what they might be able to do about their case?
Absolutely. You can reach out to us here at the firm, JGLLAW.com. That's our firm website. 2 L's back to back, I always say to people, or you can reach us at 301-220-2200.
All right. Thank you both for coming on today. Melissa, thanks for coming in long distance. Matt, thanks for taking time out of your day. This has been just fantastic. Everyone out there, thank you for listening in. Hope you join us for our next episode. I'm David Bullitt, and this is JGL Law for You.